All right, everybody, come on in. It is Friday. It's the Democracy Stupid. I'm Edwin Eisendrath, and I'm joined by Kate Riga this week. She is maintaining her sanity covering the Supreme Court for Talking Points Memo, where she also co-hosts podcasts with Josh Marshall. We talked on a different show, on my radio show a week ago, and Kate was brilliant. And I thought a bigger audience needs to see her. So you're in for a treat.
Well, thanks for having me
You bet.
On this calm, placid week.
It is a calm, placid week, isn't it? Wow. Before we get to some of the madness that's the present news, I want to spend some time on the Supreme Court with you. In particular, because I don't think the destruction of the Voting Rights Act is a news cycle event. It's a generational cycle event, so they don't get off the hook by changing the subject so quickly. They didn't just wreck this great law. They also violated something that they put in place called Purcell. And I wonder if you would teach everybody what that is, talk about how it's been used in the past and how it's been ignored in the present.
Yeah, I'm so glad you brought this up because I think being shrouded in the Purcell principle makes it seem like some kind of deified legal procedure that the court is bound to follow, when what it really is made up out of whole cloth and has been bent towards the almost exclusive purpose of upholding voter restrictions and delaying remedies to those restrictions or disenfranchisement. And even when we go back to the beginning, you can see how this is just concocted out of thin air, right? This arises from a 2006 case over an Arizona voter ID law. And the Ninth Circuit had said, we're only 3 weeks, a month out from the election. This is potentially illegal. We're going to put it on pause for now while the litigation plays out, and then we'll kind of see where we land. And the Supreme Court, via the shadow docket in a 2-page unsigned majority, says, no. We're so close to the election. This risks confusing voters. We have to put this voter ID law into place right now, which was a new law. So it gave election administrators 3 weeks to put a new ID law on the books, right? Where the clear risk to disenfranchising voters comes from the implementation of the law, not the temporary blocking. And then since then, it has just become a monster, right? In that case, we're talking about a few weeks before the election, and it has since completely been contorted to expand for as long as the conservative supermajority needs to put any kind of voter remedies on pause. And I think one of the worst ones here was Merrill versus Milligan.
Hang on, before you get into the case, I just want to be clear with everybody because it is complicated. So what they said, what the Purcell idea is whatever the case, whatever the action the court wants to take, they shouldn't take it too close to an election because it can be confusing. It's a pretty simple idea, but as Kate's telling us, it's been used to stop the court from taking actions, which in effect means that actions do get taken close to the election, or vice versa. And it's always been used on the same side.
Okay. And it's completely unnecessary because in these cases where, the voters and the groups that represent the voters are asking for emergency relief from, the maps or the voter restrictions, the court already has a set of factors to consider when they're mulling granting that relief, right? That includes things like, harm to where the public interest lies, the harm to the plaintiff. So they already have this set of factors which would let them, look at these asks and determine if they're necessary. But Purcell, like you said, because it's this vague idea of it'll confuse voters if it's, quote, too close to the election, when too close has never been defined, lets them kind of throw those other factors out the window. And that's how we keep getting decisions on the shadow docket where they say the confusion to voters outweighs, say, a map that a lower court has found to be unconstitutional, right? Or a voter restriction that is illegal.
Which you're going to get to it. You're going to get to the map in Milligan.
Exactly. So in Milligan, plaintiffs brought this case in 2021, a full year before the election. And they did this cognizant of Purcell, to be very careful to say, there is no way you can say we didn't take action in time, right? We filed suit right away. And this was a garden variety Section 2 VRA case, back when we still had those, which is Alabama has illegally diluted Black voters. They need to have 2 majority Black districts to give those voters an opportunity. So the court, in this weird Kavanaugh concurrence, invokes Purcell to say we have to, keep the lower court decision on ice, which had found that this map was illegal. We have to proceed with the one Black majority district map, which again, a lower court has found to be illegal because it's too close to the elections 7 months out from the primary election. So you can see how from 2006, this ballooned from 30 days to now we're encroaching on a year. And that still doesn't give you enough time to be
So
out.
in Milligan, they said, no, you have to keep unconstitutionally racially discriminatory districts in place because it's only a year from the election. Fast forward to this week.
Yeah, exactly. Well, and to add insult to injury in that specific case, they ultimately ended up upholding the lower court decision that the map was illegal and made Alabama redraw, right? But yeah, as you say, this week, all of a sudden, where is the Purcell principle, right? They expedited the certification of Calais to let Louisiana redraw their maps after tens of thousands of votes have already been cast. They lifted an injunction in this Alabama case to likely let them use this one majority Black district again after voting had already begun. And this is just on a backdrop where in various of these cases, they'd even done Purcell because it was too close to a candidate filing deadline in a primary, right? So these are it's inconsistent. And I mean, it's just clear fact. They only use Purcell when they're upholding a decision that will likely help Republican candidates or at least hurt Democratic ones.
So when John Roberts opines that mortals like me don't understand the complexities of constitutional law, and therefore we shouldn't stand in judgment of his blatantly political racist acts, I agree. I don't understand the complexity of constitutional law, but I understand politics and I understand the timing of decisions. That has nothing to do with constitutional law. That has everything to do with putting your thumb on the scale for partisan reasons. And so there's no cover under the guise of, we've just studied the law more carefully for making decisions on a schedule that's blatantly political.
Yeah, absolutely. And, right now in this post-Calais movement, everyone's kind of rushing to see how many safe seats Republicans are going to net after this decision. But Purcell already cost Democrats probably 3 or 4 seats after 2022, simply because they refused to act on these unconstitutional maps until after the election. And remember, in 2023, Republicans entered with a 5-seat House majority. Right. So, I mean, they've already netted, unfair advantages from this.
Well, I mean, the Ohio Supreme Court said their congressional and local maps were illegal, and they ran out the clock, and the Supreme Court said, oh, you don't have time. You have to use the illegal maps. So, yep.
Bummer. Nothing can be done. That's the law.
I believe this court, by behaving that way, has created an unimaginable constitutional crisis. But acting on that belief is almost as dangerous as pretending it isn't true. I mean, imagine, Kate, if the next president says the government will enforce the Voting Rights Act, period, and that Congress shouldn't seat anyone coming from an illegal district. That is a fair consequence of their decisions, but a really dangerous one. Or if that's not the law you think they got egregiously wrong, we will enforce the McCain-Feingold Act and not let billionaires pour money into campaigns, period. And if they do, we will prosecute them as if Citizens United didn't exist. I mean, we are on the edge of that fight. So I guess I want to ask you, because I used to be a very lonely man in arguing for Supreme Court reform. Now I can barely get into the room. There are a lot of people who have said this is just crazy. So what do you think? What reforms are possible now? And so talk about a couple of them, and what kind of courage will it take to get them done, and how do those of us who aren't in office help them find that courage?
Right. So I think right now the reforms that have the most traction, kind of both from, a smattering of Democratic politicians and
Yeah.
then some academics and activists on the left are, court packing, court expansion, term limits, and then jurisdiction stripping. And some of these, the idea is to, combine multiple. But I'm sure you've noticed in recent weeks, it feels like there's been some coalescing around the court packing idea, even from Democrats, particularly potential 28 hopefuls that you wouldn't usually associate with the wing of the party that is more amenable to, radical structural reform. And, that's Kamala Harris. You have Ruben Gallego. You have kind of normie Dems embracing this. And I think the court packing idea has gained such traction because we definitely know it's constitutional, right? Congress has done this a bunch before, changed the size of the court. And it's something that you could theoretically do right away. A trifecta sweeps in 28, the Democratic Congress and president put up new justices and bam, right? It happens right away. But the go ahead.
No, so just so we're clear, so people understand, the packing word just means expand the size of the court, right? And traditionally, the courts have well, for a lot of American history, there've been the same number of Supreme Court justices as federal judicial districts. That would be 13 now. So we haven't expanded the court as we've expanded the judiciary.
Right. And there have been long calls to, expand lower courts as well, that their workloads have become big. This was not really a controversial idea until recently when you apply it to the Supreme Court. And to be clear, Republican states have done quote unquote court packing very recently. Utah, Arizona, and Georgia all expanded their courts by 2 seats in order to lock in right-wing majorities. So even though—
Oh, I didn't know that. Say that again. Yeah. Utah,
Arizona, and Georgia. Utah has happened because their Supreme Court was kind of dutifully enforcing this voter-passed restriction on partisan gerrymandering, and the legislature got fed up with that. So they said, let's expand it, put 2 partisans on. That'll be enough to get our maps through. And then Georgia and Arizona in the 2016 cycle both had concerns that their governor's mansion was getting more competitive. So they were like, you know what, let's lock in these right-wing majorities now before we have to worry about it. Which obviously is still, that's a huge cloud looming over all of these kind of potential statewide midterm battles, right? We're always like, Democrats have to commit to winning state Supreme Courts. Right. But Republicans have already kind of structurally cheated to make that much harder to achieve in a couple of these swing states.
I'm up here in Chicago. I was very much part of the fights to transition the Wisconsin Supreme Court from a completely partisan mess to an actual court. And that was a big fight. And the good people of Wisconsin took it seriously and have delivered now multiple times in a row to make it happen.
Yeah,
but it's hard. It's a hard fight.
And it's a harder fight when, Republicans keep changing the rules to give themselves an advantage, right?
Okay, so one of the reforms that you talked about, expand the court.
Yep.
Got it.
Okay, 2 is term limits. And now this one has some more kind of constitutional fighting about it, right? Because the Constitution guarantees that the justices can serve, while they're exhibiting good behavior. And that has long been interpreted to mean that's a lifetime appointment absent, impeachable acts. But there have been some academics, the Brennan Center has kind of been out front on this, who kind of devised a workaround that wouldn't require a constitutional amendment, because obviously we're not living in a world where a constitutional amendment is viable. And they say you can do this through a statute if you give the justices 18 years to serve on the bench, and then you put them on senior
Senior
status.
status, right.
Yep. And then they ride the lower circuits, which is kind of more similar to how the Supreme Court used to look. And that the leading bill to do that is called the Term Act, which the someone at the Brennan Center told me this week has just kind of been lit on fire these past couple of weeks with all the co-sponsors they're getting from members. And that would take effect right away. So Clarence Thomas would be first up.
Let me say that differently. They get a lifetime appointment. Absolutely. We're not saying they don't get a lifetime appointment, but that lifetime appointment is 18 years on the Supreme Court and the rest of their life as part of the federal judiciary.
Exactly.
Yeah.
So the thing with both court expansion and term limits, though, you're going to have to pass a law to do that. And then the question comes, well, how do you stop the current court from just striking it down, right? Even court expansion, which is so blatantly constitutional, does anyone have a lot of faith that this court would kind of willingly decrease their own power in the name of upholding the clear meaning of the text of the Constitution? So there have been some ideas floating around that would involve this idea of jurisdiction stripping, which is also very clear in the Constitution. Congress gets to do. It gets to decide the jurisdiction the Supreme Court presides over.
Well, the exception clause.
Right. That maybe you can insert that into, say, the law establishing term limits, and say, and the court doesn't get to touch this law, right? We're passing this law and it's not in their jurisdiction. And Democrats have kind of toyed with this already in a different law called the No Kings Act, which hasn't gotten any traction because it's been, Republican government, but that would block the court from hearing cases about presidents' criminal acts, right? To try to defang the immunity ruling. So this idea is already in the ether.
Well, these are good ideas. I mean, I note that this is not new that we've needed Supreme Court reform. When Joe Biden first was elected, we talked about this, and he put in place a commission that was meant to float the ideas that would later lead to court reform. They recommended none of the things. They couldn't agree on any of them, but they floated some very interesting ideas, including some of the ones that you mentioned here.
That's right. And I think the problem there was Democrats had started to recognize that this Supreme Court is just untenable, right? That it, aside from the kind of stripping of civil rights, you also just have it acting as a legislative veto for Democratic administrations and a hall pass for Republican ones. And this was particularly pertinent when Biden took office and had his trifecta, and every corner of the left was kind of coming forward with their issue that they wanted him to act on, whether it be, democracy reform, environmental protections, abortion protections, right? And the concern was this court is not going to let any of that through, even if you do the gargantuan work of getting it through Congress when you have, the thinnest of majorities in the Senate and you've got Manchin in your caucus. But he was perhaps not the president to do it. Maybe the rest of these institutionalists in Congress just were not fire-breathing enough that we had this commission. They had great, intellectuals on it, great ideas, and it never really went anywhere, right? They wrote a report and then it just kind of petered out from there.
Yeah, I don't think I think I liked Joe Biden. I think some of the things he did were great. But I think they fundamentally failed because Joe himself said the biggest threat to the country was Donald Trump. And then he didn't act on it. He did nothing to protect us from this resurgent, MAGA, anti-democratic, and a small d democratic or autocratic movement that has caused these constitutional. I'm sorry, my dog is making some noise. I apologize.
He agrees.
Yeah.
No,
Right,
I think I was just going to add, I think that's totally right. And the concern now, as I've been doing reporting around all these reforms, which gets to your question about, the courage Democrats would need, is the concern to me is, let's say the planets align. Democrats sweep into a trifecta in 28 with numbers to abolish the filibuster and requisite majorities to actually, get things through Congress. Then they are going to be so sorely tempted by this kind of Joe Biden playbook of, well, what if we do Medicaid expansion, right? What if we do affordability stuff, like the popular stuff, because we know that people just don't get that on fire about democracy reform, and doing the court reforms would be hard, right? And the right-wing media and the mainstream media and Republicans would accuse them of, kind of a dictatorial takeover. And what if they decide that's too hard, we're going to do this kind of bread and butter affordability stuff? Then we're in a world where you still have to abide under this Supreme Court. How much of that agenda will stand?
That world doesn't exist. You cannot. This Supreme Court destroyed the Voting Rights Act. This Supreme Court got rid of campaign finance from. It nullifies the laws it nullifies laws that the people of America wanted. And these are bipartisan laws that were very, very important to the country, and they just nullified them because they could. It's untenable. It can't stand. But the Democrats have got to be able to do two things, right? You can do this government reform, and you can help on the other agenda, which is also enormously important to lift our lives. I mean, I know Donald Trump is doing everything all at once. It's not as hard for him because it's much easier to destroy stuff than to build stuff. But the nation's at stake. We need leaders who can do it. So from the outside, it's our job to both cheer them on and to kick them forward if they get scared, right? I mean, I feel like, I'm Joe Stalin, and I want to stand behind our troops and say, if you turn around and retreat, you're going to get shot. So move forward.
Yeah, absolutely. And I do think a lot of this, in terms of the outside pressure, will depend on who the 28 Democratic nominee is, right? Because most members of Congress take their cues from the White House, right? And that person's appetite for reform will just do huge work in bleeding down to the rest of the Democrats. You'll need to act.
Well, I'm glad to hear that, because I do not believe a candidate will emerge from the primary who isn't willing to tackle the government reforms we need. I think the public understands that. And I think that the connection has to be made between small d democratic reforms and a government that actually does its job for people. Because when you've broken the democracy, as these guys have, and we have these constitutional problems that we have, you end up with a government that works for the oligarchs. You end up with a completely for sale administration that says, oh, I'm going to sign a crypto bill. No, wait, I'm not going to. I just got to check. Wait, I'm going to do something about data, AI. No, I'm not. I just got to check. Oh, wait, I'm going to go to war in Iran because the oil companies want it and they get huge windfalls, right? That's what happens when the democracy is broken. So our candidates have to make the case that progress for the American people and progress for American democracy are the same thing.
Exactly. Yeah.
Yeah, that's not a case I've heard made very often by candidates, but maybe this time.
Yeah, it's going to have to. And I think they're just going to have to figure out a different way to package it. And I think the way that you propose is smart, right? Like, give people the tangible benefits they want and say, we have to do this to get that, right? It's not about an abstract kind of pro-democracy argument. It's about, if you want the bread and butter stuff, we have to do the reforms first.
Right. Absolutely. And do them together. All right. Yep. So this term is coming to an end, I guess, but we still have birthright citizenship. We haven't heard from them on. I don't know why that's a complicated question. It's one like clear as can be. I mean, we could pull out the Constitution and read it. What's going on?
It's been conventional wisdom around birthright citizenship that it is so clear, it's so unambiguous that even this court would struggle to go Trump's way. And I think it's also a case where any kind of splitting the baby is just very difficult to do, right? Because as soon as you are trying to partition people out based on, your parents have been here for X amount of time, or they have established a domicile, or they haven't, and what does that mean? How in the world are you going to sift people apart based on those grounds, right? Your birth certificate doesn't contain that information. It's just totally impracticable.
So what are they going to do? Why are they waiting?
I don't know. I mean,
the tariff decision wasn't hard. It was clear. Trump didn't have the power. The Congress has the power. And yet it was the most complicated decision because they spent all their time arguing about their notion of major questions.
Yeah. Traditionally, I guess the court does like to drop its big decision bombs at the end of the term, late June, early July, and then skedaddle until October. So, you could argue, well, they're just following the traditional kind of schedule. But then, you had Calais dropped in the middle of spring. I mean, no one expected that, right? The people who thought that they would drop it to help red states thought it would come far earlier to definitely give them time to do the maps. And when we passed that deadline, everyone was kind of thinking, okay, we're going to get this in the traditional late June dump of big decisions. And they've completely broken with that. So it's hard to have any confidence.
They did something this week that I thought they did two things this week that surprised me. They had a death penalty case where they just said we shouldn't have taken it. I mean, that was weird. They took a case, they argued the case, or they didn't shadow dock it. They took the time to listen to it, and then they said, yeah, we shouldn't have taken it. And that preserved a little bit. It made it harder to kill mentally ill people. Or at least it let that stand. That surprised me. The other thing that surprised me, and this wasn't a close decision of the courts, but they took a case in this fraud atmosphere when Donald Trump wants to go to war with Cuba. They took a case and then voted on it that said, oh yeah, we can the companies whose assets were taken in 1960 can sue Cuba and try and get that back. Like, that seems the timing of that case and taking that case, like 1960 was not yesterday, and then, like, we have a lot of things that need to be remedied in the country, but to take that case about something that happened in 1960, when the administration is looking for casus belli to go to war in Cuba, seems, again, outrageous to me.
Yeah, totally agree. And on the first one you mentioned, where they kind of abruptly decide, never mind, we don't want this anymore. It kind of reminds me of this abortion case they took out of Idaho, which was about the federal emergency room statutes that require, if a woman goes into an emergency room and you have to give her an abortion to save her life, you are federally mandated to do that, right? You have to give care to people in emergency rooms. And Idaho said, no, that violates our abortion ban. You don't have to do that. And that case started under Biden and has dragged into Trump. So it's since been just dropped. But, it got all the way up through the circuit, all the way up to the court. They heard oral arguments, and then unanimously they all said, nah, we're actually going to let this play through the lower courts. So thanks, but perhaps we'll pick this up later. And it ended up having the effect of, right, the case was never resolved because the Trump DOJ didn't want to fight it. So, it goes back to status quo.
Again, the timing games of the court are not, they can't hide behind their robes and pretend this is judicial wisdom. A couple other things happen that don't have to do really well. We can keep going on the Supreme Court, but I have other things I want to actually talk to you about. Related to the judiciary, here in Chicago this week, there's been an incredible story breaking about in a federal courtroom. We had this group called the Broadview Six, right? These are 6 people who were charged with felonies when ICE was here, when ICE was in their big show of force here. During their trial, they said there's some problems with the way the feds went to the grand jury, and they were convincing enough so that the judge said to the feds, we'd like to see what you told the grand jury. And the government said, oh, never mind, we're dropping the charges, and we're going to make it a misdemeanor. And so it didn't matter. But the plaintiffs, the people who were being charged said, no, you keep charging us. We want to go after, we want to know what happened. And yesterday they had a hearing where the judge saw what happened to the grand jury, and the U.S. attorney here had to admit to real wrongdoing. And she read him the riot act. I mean, I've never seen anything like this. Is this out of bounds, or is this what the Trump's DOJ is doing around the country now?
Even for the Trump DOJ, I was stunned when I read the details of this story.
Well, tell everybody what they were, because they were
right. Your outline is totally right, but there's an intermediary step between when the judge sees the unredacted transcript and all of a sudden the charges are dropped, which is before this, she had asked, well, kudos to the defense attorneys who really did a really good job here, but they were the ones who convinced her, okay, we don't need to see the transcripts, but you should see the transcripts.
Right.
And so she said, okay, I'll take a look, right? And then the federal prosecutors show up with redacted transcripts and allow her, the judge, to believe that it's due to IT errors, right? It's like erasing of the Watergate tapes. It's just so insane. And then the defense attorney said, well, I want to make sure that they explained the conspiracy charges they're trying to bring properly to the grand jury. So take a look at the unredacted transcript and make sure that's what happened. And then the misconduct that was revealed was just unbelievable. You know, you had prosecutors, they call it vouching, right? Putting their own credibility on the line to say, no, you can take my word for it. These charges are true, right? I swear on my mother's grave or whatever. You have,
by the way, that's not evidence. Like, they're supposed to show evidence. Yeah.
Right. You have grand jurors who are expressing, you know, disagreement with the government's case, leaving, being asked to leave, you know, rather than
I don't like this man in my jury, so I'm gonna find goodbye.
He doesn't like my case, so I'd rather get someone in who does, you know. You had little stuff like attorneys are talking to the jurors outside of the hearing room, right? I mean, it's just all over the map. And the judge said, you know, she's read thousands of pages of transcripts from grand juries, never seen anything like this before. And even the Trump U.S. attorney had to kind of start out doing this mea culpa of like, well, this was my assistance. I didn't know about this until recently. You know, no one was trying to mislead you before, in such a Trumpian term, right? He takes a left turn and says, but what they did was not acceptable in a civil society. And the judge was like, okay, hold on. If you're going to apologize, apologize.
Right. You can't have it both ways.
Right.
Yeah. So I wonder if this, I mean, again, it is a story that hasn't yet caught a fire across the whole country, because it happened here. But I wonder if this will, I mean, as far as this judge is concerned, there is no regularity. The federal government no longer has credibility in her courtroom. And if they say the sun is shining, she's going to say, open the window. I want to know for sure. And I wonder if this is going to matter across the country.
I think it has to, because it's just another data point that weighs against the way things have always proceeded, right? Which is that traditionally the government side in federal court gets, you know, the presumption of regularity, the presumption of trustworthiness. You know, these are big fancy lawyers and big important jobs, and the government's usually only involved when they think it's a big important case. And traditionally, you know, not always, but that has been pretty good motivation for these attorneys to act within the bounds of the law. They want to win the case, right? They don't want to get things thrown out because it's tainted or because they acted wrongly. But how many times have we seen things like this? Maybe not to this extent, but things like this throughout the Trump administration, where they won't comply with court orders, or they're, you know, giving, you know, confusing evidence when the judge asks for proof of things, right? Like, this was coming up all the time during the deportation flights, where they were trying to get people out of the country, even when the judge says, okay, stop. I'm trying to find out, when is this flight leaving? How much time do I have to hand down? Yeah, exactly.
Right. And they said, hold on, I'll find out. Quick, launch the plane.
Get him off. Right. Yeah. Exactly. I mean, it's just the breakdown of that professional kind of conduct is just stunning and has such profound ramifications for
the rule of law gets shattered.
Exactly.
Right. All right, I got one other topic before I'm going to let you go, because how could we not talk about the slush fund and the very idea that the Justice Department would say, forever, we are not going to bother to check your taxes.
I know. And 1.7, almost $8 billion of taxpayer money, you know, you're welcome.
Yeah, to pay for his insurrectionists. So exactly. They can buy arms to do it again.
A nice detail of the Chicago, the Broadview Six case that I liked is that the defense attorney said, we're going to apply for money from the slush weaponization fund because they've been improperly targeted by the DOJ, right?
Yep.
But I have to say, the thing about the slush fund that is shocking to me is not so much kind of Trump's role in it, right? This is the very meat of his character, is this kind of thing, theft of taxpayer money to pay off his rich friends and cover up his malfeasances. But the genuine anger that seems to be arising, particularly from Senate Republicans who have been completely complacent and invertebrates for most of the administration so far. And you get the sense that a little bit of this is kind of supercharged by the fact that, Trump went after Cassidy lost, right? He endorsed Paxton instead of Cornyn. And I think they are being sensitive to their friends, their buddies, one of their own being driven out of politics because of Trump's little vendettas. But they clearly think this is bad politics, and they do not, want their fingers on it. They don't want this.
They didn't try and stop him. They just said, please don't make us have a vote on it.
Yeah.
Right.
Well, and then
that's their form of courage. It's not much.
Yeah. Totally. But vamoosed from Washington rather than pass this big ICE funding bill because the slush fund is at all kind of connected to it.
Well, because Democrats would have forced them, because when you're in a reconciliation bill, you have these votes. They were going to force them to vote on this, and they didn't want to have to do it.
Absolutely.
So good for the Democrats for figuring that out.
Totally. And on the heels of making them swallow, however much money that was for security for the ballroom, those are
they didn't do that. In fairness, they couldn't do that. They didn't have the votes for that. They took that out.
Mm-hmm.
Yeah. Well, Kate, this was fun.
Fun quotes.
Thank you. No, thank you. I mean, it's really helpful to get to get into the weeds a little bit on this court stuff, because it's just so important.
Mm-hmm. And they do hide behind this procedural stuff because it sounds wonky and hard to understand, but it is key to how they're kind of perverting their power to help their partisan allies.
They hide behind their robes. They hide behind the columns. They hide behind the reputation that court earned, that other jurists on that court earned for decades, and that they haven't earned, and they hide behind it.
Absolutely.
Yeah. All right, Kate. Well, we'll do it again.
Yeah. Thanks so much for having me.
You bet. Take care.